This in fact is well within the bill, because what we are talking about is the Premier endorsing a process whereby a couple of people who are suffering from acute illnesses are frozen out of society. Now, you know, that's something that I find impossible to believe in this day and age, in 2021, in a supposed civilised state. Just extraordinary, and certainly within the powers as prescribed in this particular legislation. On another matter, I wish to draw to the attorney's attention something that happened in my electorate just very recently, and I'm sure the attorney will be very aware of what I'm talking about, and that is the raid by authorised officers of the government. Authorised officers, very Stalinist, that term, isn't it? But it was authorised officers by the government that raided a local doctor's surgery in Sunshine, a doctor who had been a family GP in that area for 30 years. You know, he had treated in that time thousands of local people. There are many local people who were dependent on him for their health care. He was a man, or is a man, who was much loved in that community, a man who was very much respected in that community, but he was raided. He was raided for reasons that I'm not aware of by the authorised officers. Not only was he raided, but his medical files were taken. Now, this seems to me to be a severe and clear breach of the doctor-patient relationship. We hear a lot about that in certain instances. In others, apparently it doesn't matter. This is one of them. And I would like to know, if under this legislation, what has happened to Dr. Mark Hobart in Sunshine is likely to happen to other doctors around the state. Will this be a regular event now under the Premier's control? Will we see doctors being raided? Will we see doctors being closed down? Will we see confidential medical files being taken away, and God knows how many people left without a GP to look after their health issues? Is this something that we can expect to see if this legislation is passed? Can we expect to see it on a regular basis?
Attorney.
Thank you, Deputy President. And Mr Finn, whilst it would be inappropriate for me to comment on the specifics of the situation that you have articulated, the crux of your question is the power of authorised officers. Authorised officers have formed a key component of the COVID-19 response. They've been critical to compliance and enforcement, quarantine arrangements, contact tracing and the operation of public health directions. The on-the-ground support that they've provided has included functions such as meeting international and domestic arrivals at airports and other ports of entry, issuing detention notices to facilitate the quarantine program, undertaking compliance checks, inspecting businesses and undertaking enforcement action, including issuing infringement notices where the power has been delegated by the Secretary. Under the new part in this bill, authorised officers will continue to perform this critical role. In addition to general compliance and enforcement powers and the existing suite of public health risk powers, authorised officers can be authorised to exercise pandemic management powers when a pandemic declaration is in force. The bill provides for the CHO to authorise authorised officers to exercise the pandemic management powers, and the new powers are additional to existing powers already available under the Act, including the public health risk powers and general compliance and enforcement powers. It's worth noting that authorised officers weren't created by the pandemic. They existed before that, but have been obviously deployed to respond to the challenges that we have been presented with. There are two categories of pandemic management powers under the new part: pandemic management order powers powers that relate to pandemic orders, and authorised officers may take actions to give directions to implement or give effect to pandemic orders made by the Minister. This includes giving directions to ensure persons comply with pandemic orders. An authorised officer may also detain persons in accordance with a pandemic order that requires a person to be detained. Authorised officers also have separate powers to take actions or give directions that they believe are reasonably necessary to protect public health. The types of directions that may be given are similar to restrictions that may be imposed under a pandemic order. This provides for residual power for authorised officers to impose reasonably necessary requirements to protect public health and where these are not already regulated under a pandemic order. A direction given by an authorised officer must not be inconsistent with a pandemic order, and recognising the pandemic orders are the key instrument through which population scale requirements may be imposed under the new part. Authorised officers will usually only be able to give directions applying to one person apart from certain persons in limited circumstances. And Mr Finn, it is certainly worth noting that the actions and decisions of authorised officers are certainly subject to a review from the Ombudsman if there was a complaint about somebody that was unhappy with the experience that they had with an authorised officer.
Mr Somyurek.
Thank you, Acting President. Acting President, when we met, when it was the bushfires in January 2020, when we were in the middle of the bushfires, we were called in to discuss the bushfires, be debriefed by the Commissioner of Police and the Emergency Services Commissioner at that point. At that point, we were told we were going to go into a state of disaster. Now, we got to understand the full breadth of powers that the state has when we go into a state of disaster, and many of us were surprised that we didn't have to go to Parliament to exercise those powers. We were actually shocked, many of us ministers around the table. So a few months later, unfortunately, we had to do the same thing. We were debriefed on our state of emergency powers. Again, we learnt we didn't have to go back to Parliament to be able to utilise or exercise those powers. Again, it came as a bit of a shock. We were wondering around the Cabinet table at that point. We saw pictures of Yuan. People were being locked down. We were wondering whether we would ever be able to do that in the state of Victoria, in the Western world. We thought we wouldn't be able to. We thought we wouldn't have the social licence to do that. So we were a little bit concerned, and we were wondering what we were going to do to sort of be able to deal with the pandemic if it came to Australia. Now, fast forward 20 months down the track, what it proves is Australians are law-abiding citizens, and they like their order and they do follow laws and rules. So we've actually managed it quite well. The government's utilised its extensive extreme powers that have been there. However, when I look back and just looking at how we've locked down 6.5 million people, we've imposed curfews on 6.5 million people. I'm not saying that was a wrong thing to do. I'm just looking back at the powers that we've got. So when I look back now, when I think the government and I agree that we do need reform of the Act, but the only problem is we come to that reform from diametrically opposite directions. When I look back over the last 20 months and look at the extreme powers, extreme coercive powers that the government, not just this government has at its disposal, I think, well, what do we do? How do we bolster those safeguards? How do we bolster those checks and balances? That's where I think the next direction of reform needs to come, because it is open to abuse. Not just by this government, it might be a Matthew Guy-led government in 12 months' time. I don't want Matthew Guy, who gets a bit of white line fever, to be exercising extreme coercive powers and, right? So any government, not just Matthew Guy or this government. It's about government exercising those powers. That's my perspective. So, President, when I look at Deputy President, when I look at this bill, I see a bit of Orwellian sort of, doublespeak. I see synthetic or illusions of accountability mechanisms. But what this bill is really about is, whereas I looked back and thought we need to bolster our checks and balances and safety mechanisms, this bill is about a government that's been irritated by those very weak mechanisms that are in place now and wants unfettered to use those extreme powers in an unfettered way. Again, I say to those opposite, to everyone, that it doesn't matter what government it is. It doesn't matter if it's Daniel Andrews, Matthew Guy or a Finn government in the future. What matters is that government should not have access to unfettered powers. That's my issue. That's my issue. So the next part of the reform, what we ought to be talking about now is how we're going to bolster those safeguards, the checks and balances, the oversight, accountability, transparency measures. So, Deputy President, now there's obviously a myriad of complaints about this bill. There's been complaints from the Law Institute of Victoria, Human Rights Commission, from the Ombudsman, from the Bar Association, from the 60 QCs who've penned a letter, picking holes in the bill. But what my expertise is, both from a theoretical perspective too, because I think I know Parliament pretty well and I've studied it pretty well, but also from a practitioner's perspective, I'm concentrating on the parliamentary angle. So from my perspective, three issues. One, politicisation of the pandemic. Two, removal of independent oversight. Three, erosion of parliamentary accountability. Now, when I talk about the politicisation of the pandemic part, I'm basically talking about the transferring of legal authority to make pandemic orders or health orders away from the independent medical expert and to a politician. Now, I know I'm going against the grain, and I know even some of those groups that have written in complaining will look at it from a theoretical perspective and say, of course the parliamentary accountability, of course the minister should have those powers. But and I'll explain why it's wrong. For a start, when you're transferring those powers to a politician is motivated by good public policy, but a politician is also motivated by, and has to be motivated by, winning the next election. Why? Because that's not just expediency. That is, if you believe in your party's ideology, you believe in your party's values, you believe that your party governing for the state of Victoria is the best thing for the people of Victoria. So the politician has to have one eye on the on winning elections. So, President, Deputy President, and I also believe that when you're in a crisis situation, no matter what that crisis is, it could be war, it could be natural disaster, it could be a public health crisis. When you're in a crisis situation, the first thing any democracy ought to be doing, the first thing every democracy ought to be doing is taking the politics out of that particular crisis, right? Taking the politics out of the crisis. We've seen that in the past with War Cabinet. What happens in a War Cabinet? You get bipartisan support, right? We saw that with Prime Minister Morrison when he called a national cabinet. That was all about depoliticising the pandemic, and that worked a treat. We looked at the United States where they were all at each other's throat, and in Australia we were kicking goals. That was working very, very well. Right? So what I say to you, depoliticising or taking the politics out of the pandemic is very important. Unfortunately, right now we're still in the middle of a pandemic. This is the wrong way to go, right? There needs to be a discussion, and I do agree there are some problems with an unelected official being able to close down a whole state, but I think right here, right now, transferring this authority in the middle of a pandemic, it goes against the grain of what you should be doing in a crisis situation. Two, removing independent oversight. Now, that is essentially nobbling the Ombudsman, right? It's nobbling the Ombudsman. The Ombudsman's role is to review, is to monitor, is to investigate, is to report back on administrative decisions. Right? And the Ombudsman's done a good job. The public housing towers in Flemington was a very, very, very strong report. We got an insight into how the public health orders were actually made, you know. So it was a very strong report. Now, we need that. When you're talking about such extensive coercive powers, we need that independent oversight. Very important, very important. The next thing is the erosion of parliamentary accountability. Now, what I'm talking about here is having to not come back to Parliament with a state of emergency or a pandemic declaration. Now, I've been critical of the status quo. I've been critical of the current Act, which reflects my amazement in January 2020. I've always thought if you're declaring a state of emergency, surely you've got to go to the Parliament. The Parliament represents the will of the people. And what a better way of testing your social licence than going to Parliament to lock people up, to lock people down and to impose curfews. Again, I'm not being critical of the government for doing that. I'm more talking about the accountability mechanisms here. So even the status quo, you should not have to wait. I mean, I believe you should have to come to Parliament within 6 weeks to get the state of emergency declaration ratified by Parliament. But what's been proposed here goes diametrically in the opposite direction. You never have to come back to Parliament. You never have to come back to Parliament. So you can actually rule by decree. That's wrong. Again, my perspective is, and it has been since the very first day I heard about this in the Cabinet in January 2020, is to say, well, you've got to go back to Parliament for this. So again, this goes in a completely separate direction. So, Deputy President, I've read the amendments. I think it's a step in the right direction, the amendments, but I don't think they go far enough, and I think in theory they're okay, but in practice they're not going to be much value in terms of holding, in terms of, again, safeguards and checks and balances, because look at the numbers. The lower house, when you're talking about a joint sitting, lower house 174 or 8 people. Look, there's four times more lower house members of Parliament than there is upper house members of Parliament, and a government is formed in the lower house. So I think at the end of the day, whilst it was a valiant effort by Mr Barton, at the end of the day, I think in practice it will be of little utility. So with that, Deputy President, I'd also like to declare to the House that I won't be voting on the amendments, but I'll be voting against the bill. Thank you,
Mr Somerick. Attorney?
Thanks, Deputy President. There's a little bit in that, Mr Somerick, and I guess you did miss your opportunity to contribute to the second reading debate, so fair enough that you wanted to put some things on the record. There is a few points in there that I would just take up, and a lot of them will be covered in sections of the committee, but I would point out that no other state has been required to return to Parliament. That was an anomaly here in Victoria, for which we, during the state of emergency extension debate, all pretty much agreed was not a satisfactory arrangement, which is one of the reasons that led us to craft a bill that was fit for purpose and responded to the needs of Victoria based on the experiences that we had had. You're incorrect to say that there is any change in relation to the Ombudsman's oversight. She has endorsed this package and, for the record, would still be able to conduct an inquiry such as the tower review that she did under this framework, as she does and has always had under the previous legislation that is in existence now. You mentioned the concerns of a range of stakeholders. I can confirm that The stakeholders that you mentioned are all on the record today encouraging the Parliament to pass the bill, including the Centre for Public Integrity, the Human Rights Law Centre, the LIV, the Ombudsman, as I mentioned. I'll give you a list. I can give you a list of all of the people that are on the public record today supporting the bill. So, Mr. Somyurek, yes, they've raised concerns, but the government has listened to those concerns, responded to them, whether directly in consultation with those stakeholders, or indeed Mr. Barton and Mr. Hayes took on a lot of the issues that were raised by stakeholders and have been addressed. So. I guess in relation to the issues that you raised, the only other thing I would point out is that you make the observation that it is your view that you don't think a government should be able to rule by decree, I think was your terminology. Mr. Somyurek, there must be a pandemic that exists and has to be on reasonable grounds to be of concern to the health and safety of Victorians. So this is about ensuring that the government has adequate powers to protect Victorians, not to arbitrarily make rules that don't actually don't actually have a purpose of protecting their lives. So, Mr. Somyurek, thank you for your comments, and if you've got any further specific questions, I'm more than happy to address those.
Just on a point of clarification,
Mr. Somyurek.
in terms of the independent oversight, i.e. the Ombudsman at the moment can have a look and follow and sort of investigate any administrative direction by a bureaucrat. But once these powers shift to the executive, the Ombudsman can't do that. The Ombudsman has to wait for a parliamentary. It is right. Parliamentary committee has to wait for a recommendation of the parliamentary committee, and even that is not clear. I've spoken to the Ombudsman's office yesterday. Even then, it is not clear whether the Ombudsman can actually investigate a recommendation. If you notice the wording in the amendments, it says investigate or clarify. So the Ombudsman can't self-reference. The Ombudsman will need to wait and hope that there is the numbers are there on the parliamentary committee to get a recommendation up, and even then, the law is not completely clear on that. And the other point is, in terms of ruling by decree, I wasn't talking about what's happened in the past. I'm talking about what's going to happen from now on in terms of coming to Parliament with state of emergency powers or the state of pandemic powers. So you're talking about the past. I'm not talking about the past. I'm talking about the future. I'm talking about not necessarily an Andrews government in the future. I'm talking about any shade of government. So I think it is fundamentally wrong to exercise such extreme and coercive powers without coming to Parliament to get ratification of those powers.
Attorney?
Deputy President and Mr. Somyurek, a lot of that was a statement, but categorically you are wrong. The Ombudsman can still investigate administrative implementation of the orders. She can investigate on her own motion. The powers under the Ombudsman Act in this bill and the powers under her Act are no way curtailed by this bill. Her existing powers still exist. Yes, she can investigate on her own motion. Her role is very important. If there are people that experience issues that they wish to take up, want to make a complaint, they'll be facilitated directly under this bill, and we'll be going through that process, I suspect, in quite a bit of detail in other discussions throughout the committee stage.
Mr. Somyurek.
Okay, now I got to the bottom of what the Minister's saying. Minister, you'll find that the Ombudsman can now only investigate the implementation rather than the merits. So you are technically correct, but you are not completely correct. You're talking about implementation only. Why the implementation only? The decision might be made by the executive, but then, of course, then it will need to be implemented by the bureaucracy. So then it can investigate the bureaucracy or the implementation side, not the executive making the decision side.
Attorney?
The impact of the orders, which would be exercised by bureaucrats effectively, of course, can be reviewed by the Ombudsman, and as is appropriate. But ministers are accountable to the Parliament. Are you suggesting, Mr Somyurek, that the ministers should be accountable to the Ombudsman?
Mr Somyurek?
So this is the point we need to make. The accountability mechanisms, when you're transferring power, authority away from an independent medical expert, apolitical, to a politician, you need to make sure you bolster those powers, not strip powers away. What we're doing is stripping powers away. We're stripping oversight powers away. We are. The Ombudsman can only implement the implementation, but not how the decision was made, not the merits of it. So in the Flemington Housing Commission estate example, the Ombudsman went out there and found that it was actually a crisis cabinet decision that the Deputy Chief Health Officer was forced to sign off on 15 minutes before a press conference was given. So an Ombudsman can't actually go to that level of detail right now. They will have to either wait for this parliamentary committee to get the numbers on the committee to get it through, or they can wait and just do the implementation part of it because it will be implemented by the bureaucracy.
Attorney?
Thank you, Deputy President. Mr Somyurek, there are very few people that don't believe that it is appropriate that these decisions should be made by a minister. Even the opposition support that these decisions should be not made by an unelected bureaucrat and should be made by a minister. There is a provision in the bill to establish a joint parliamentary committee who has the capacity to look at these decisions. There is no Ombudsman jurisdiction that I know of who is able to investigate the decisions of ministers. The ministers are appropriately accountable to Parliament.
Mr Somyurek?
That's exactly right. They can't, and that's why moving the decision away, very important decisions like pandemic orders, which actually gets to lock people down, they can't be investigated, right? The Parliament, yes, the ministers are accountable to Parliament. That's why we need to be bolstering accountability mechanisms of Parliament, not diluting them, and that's where you and I disagree.
Okay, Ms Crowe.
Thank you very much, Deputy President. Mr Somyurek raises some...
Sorry, Ms Crozier, we're just going to circulate the amendments, so yeah, we'll do that first.
Thank you, Deputy President. The amendments, as have been circulated by myself to members in this chamber, both last sitting week and last night, have been consolidated into one set of House amendments, and I would like to formally circulate those, please.
Thank you. For Chris to hand out a couple of these first. And we now have a run sheet as well, so members who want a run sheet, if they see the clerk. So, Ms Crozier.
You right? Oh. Right, thank you. Yes, I was just looking at these amendments and there seems to be quite a number of them. It's substantial amendments from a perfect bill that was perfect 2 weeks ago to now being completely amended. But nevertheless, I want to just go to Mr Somyurek's comments. He made a couple of comments around, interesting comments around his experience. One of when the state of disaster was declared during the bushfires of 2019-20. in January of that time, and I recall that the Leader of the Opposition was given the courtesy from the Premier that there would be a state of disaster being declared. But that never happened with the pandemic. I'm just wondering why that never happened, Attorney. Can you answer that question?
Attorney?
No, Ms Crozier, I'm not in a position to give you an answer to that question.
Ms Crozier?
Thank you. I didn't think you would. But the point being is that as Mr Somyurek said, when you were sitting around that table, you were all pretty stunned about the powers that were going to be given under the state of disaster and state of emergency. Well, under the Public Health and Wellbeing Act, the powers. No. The state of disaster was declared.
Order. Can we just have Ms Crozier explain what she's saying? Thank you.
Well, Mr Lean, I'll explain it to you. The state of disaster was declared in a state of emergency. Now, during the pandemic, no, what I'm saying, I'll start again. During the bushfires, the state of disaster was notified. There was notification. Correct. The Premier actually ran the Leader of the Opposition attorney. That's what he did. He never did this during the pandemic. He's never contacted the opposition. State of emergency, state of disaster, anything else. That's my point. Now, I just want to go back to what Mr Somyurek was saying. When you sat around that table and understood the powers that were given and the powers that were obviously being... Yeah, that's right, Ms Barth, contained in the bill, that they have had significant impacts on every single Victorian. And I'm going to go into Clause 12 when we get to the disallowance and the joint sitting, because there are still concerns from a number of people around that, and he made some points. But my point again is about that. The government, the Premier actually declared a smaller cabinet. There was a cabinet at 8. I don't think you were in that.
Crisis cabinet.
The crisis cabinet. So that was formed. It was very, everybody was very aware of the significance of the pandemic. Well, good. I'm glad you are, because I think this is important. Again, it goes to the transparency about what has happened over the last 20 months, because there has been no transparency. There hasn't been any transparency about the advice that's been provided. And in the second reading speech from the Minister, to go to Mr Limbrick, to follow on from what Mr Limbrick said, the Minister's second reading speech said, "This bill is built on many lessons from the management of the COVID-19 pandemic in Victoria, Australia and around the world." So the reason I started this discussion with you was around what had happened from the bushfires, the lessons learned from the state of emergency and disaster declared from the bushfires and the pandemic since early 2020. So surely if the Minister is saying there are lessons learnt, what are those lessons? Because I don't think you actually answered that question appropriately to Mr Limbrick. Understanding what Mr Somyurek has just told the House of his concerns about when you sat around that cabinet table, you were there. So what lessons have been learnt, and why has it taken 20 months to get to this point if there were concerns raised way back then?
Attorney?
Thank you, Deputy President. Ms Crozier, the lessons learned is the experience of the last 20 months and how that has fed into the development of a framework that effectively enables the government, along with its health officials, to successfully manage the challenges thrown at us by a pandemic. I'm not the Health Minister. I'm very fortunate that I'm not. That is the toughest job going around. But it is a collection of people's experiences, lessons learned, same thing in terms of making sure that we come up with the most appropriate set of legislative requirements that enables the government to do what it needs to do, whilst also facilitating public confidence, the provision of information, the involvement of members of parliament, effective oversight and transparency, and The bill in particular responds to the concerns raised by stakeholders about needing more transparency. That's why there are requirements set out as they are. And I can't go into the details of every lesson learned because I didn't learn them. We had experts feed that in. We had Professor Doyle, who spends time in the COVID ward, telling people about, the importance of these measures. We had Professor Pfizer, who's an administrative law expert, making sure that we have a framework that is robust to challenge. And I would say that a lot of these orders have been tested in the courts. Some that have been successful and some are ongoing. There is a number of people who have contributed their experiences and their advice to craft a bill. And as you point out, I've circulated amendments which, I think appropriately, once the bill was public, there was further questions asked, and we've clarified and made further amendments to address any of those concerns, and indeed with the intention of ensuring that the public have, as I said, some confidence about the way government forms its decisions and indeed will execute anything that is in the interests of protecting the Victorian government. I think the new detention appeals panel is a very clear example of us listening to the concerns of stakeholders and people wanting to make sure that they knew the processes were particularly independent and robust.
Ms. Crozier.
Thank you, Acting President. Attorney, I think you said protecting Victorian government. I think you meant protecting the Victorian public. But you also said that there's been a number of challenges in the courts. So I'm wondering, what's the legal bill been for the Victorian taxpayer to defend the government's decisions that they've made throughout the pandemic?
Attorney?
Ms Crozier, that is certainly outside the bill, but it is certainly appropriate for the government to respond to legal action that is sought to question decisions that we've made in connection with the public health response.
Ms. Crozier?
Well, I think we'll be asking those questions again at PAAC, but we also asked for the stakeholders. You mentioned the stakeholders, and I'm looking forward to getting that list before we finish this evening, because we won't be back in the Parliament till February and we need to see those lists and the SARC report that was mentioned by Mrs McArthur. But I want to go on to the point that you make about the framework, because in the Minister's for Health second reading speech, he said, this bill will provide a fit-for-purpose framework which will facilitate the critical management of COVID-19 and the safe transition to the next stages of the national plan. It goes on to read, with all epidemiological evidence indicating that the threat and unpredictability of COVID-19, while declining, will remain in our community for some time. New legislation is essential. So I'm wondering if you could all not only provide a copy of that epidemiological evidence that outlines how long COVID-19 will remain a threat to the community that you have, understanding that I think we all appreciate that COVID is in the community, that it is going to be, it is in some states. Hang on, I haven't finished.
Well, I'm just interested in, I guess, the point of order. I've read the documents that we've tabled in the chamber, and it covers off on that exact point that you're asking for more information on.
The epidemiological about the COVID-19.
Yeah.
Could you just provide to the committee, could you outline to the committee what it is?
I just remember reading it in the documents that were tabled. So I would draw your attention to the documents that are tabled at the monthly extension of the state of emergency, which went into that. I found it fascinating. I started to read it, but I'm not in a position to give you advice or regurgitate that advice because it's not my expertise.
Well, thank you,
Ms. Crozier.
Acting President, but I don't know that we have received, that's the point, I don't know that we have received all of that advice, because there is modelling, there are new treatments, there are a whole range of, well, I'll go back and have a look at it, and I will go back and have a look at that.
I'd encourage you to, and also Certainly public.
My next, look, there is some modelling that is public, Minister. We know that. The modelling and some of the evidence has not been all made public, and we know that too. So there has been modelling that has gone on, that some of it has been made public, I concede, and know that. But there is also other evidence that you would have had and advice received from the CHO and others that has never been provided. We know that. We've been asking for it in this House. But I'll go on to talking about how you've framed this bill. It's being framed for future pandemics, but isn't it the intention that the government wants to utilise the powers, wants to utilise the powers contained in this bill for the foreseeable future? So my point is... Thank you. So my point is that we've got the current situation. Thankfully we've opened up. We've got Omicron that is being looked at. We've had a lot of concern around that variant, and others, various individuals are saying it's not, we need to wait and see. And I suppose the point is that it's providing, there's just a lot of uncertainty. And this bill goes to the point that if that Omicron, as we know, came from South Africa, that the government could make decisions based on what is happening around the world. That's what how the intent of the bill was written. So Attorney, well, it's said in the legislation about it doesn't have to be present in Victoria, is the point.
Attorney?
There's got to be a serious health risk to the Victorian public from the pandemic. So the suggestion, which I've heard, is bandied around out there that, there may be some disease in the Amazon and all of a sudden the Victorian government's going, oh, hang on, there's a pandemic there and there, so we're going to declare a pandemic here in Victoria. That's just ludicrous.
Dr. Buck, sorry.
Thank you so much, Deputy President. Could I just follow on from that question to seek some further clarification from the Attorney on exactly this point? So the bill says that a disease of pandemic potential, rather a disease is a disease of pandemic potential if at that particular time the infectious disease has the potential to give rise to a pandemic but is not yet a pandemic disease. And so the Attorney's right. Much of the feedback that I've received in many of the conversations that I've had, for example, with constituents, have been around exactly this point. And certainly my advice is that the wording here is very loose, but I wonder if perhaps the Attorney could talk us through, exactly who would be making the decision about whether or not a pandemic disease, or rather a particular disease or an infectious condition, was a disease of pandemic potential, and how that process would work if, as she says, through you, Deputy President, that she's keen to allay people's fears about this element of the bill.
Attorney?
Thank you, Dr. Buck. That's a good opportunity to address some of the issues that Ms Crozier has put on the record. So a pandemic declaration can be made when the Premier is satisfied that there is a risk to public health arising from a pandemic disease or a disease of pandemic potential, as you've identified. The Premier may make a pandemic declaration whether or not the pandemic disease or disease of pandemic potential is present in Victoria. This is to address circumstances where a disease emerging in another jurisdiction presents a serious threat to Victoria, so precautionary and proportionate actions can be taken to ensure the disease does not take hold in Victoria. I think at this point it would be useful just to point out the history and how governments have responded to pandemics. Like, for instance, it wasn't there was no state of emergency called to respond to H1N1, for example. The intention to use the legislative framework is only in genuine areas of need. In making or varying or extending a pandemic declaration, a number of steps are required. The Premier must consult with and consider the advice of the Minister for Health and the Chief Health Officer. The Premier must also prepare a report to be tabled in Parliament that includes a statement of reasons for the making, variation, extension or revocation of the pandemic declaration as the case may be, a copy of the advice of the Minister and Chief Health Officer's advice in respect of making the declaration. Where a declaration is being varied, they have to provide, he or she has to provide a summary of the pandemic orders made. And also the ability of the Independent Pandemic Management Advisory Panel is that they can also review orders. So this is setting out a very robust but a flexible arrangement so that appropriate measures can be put in place to protect Victorians from a pandemic. We've seen, you know, who anticipated a one in 100 year pandemic occurring right now is what we're experiencing. So the legislation is designed, as Ms Crozier has identified, to deal with the situation now, and unfortunately, hopefully, we don't have to use it in the future, but we have tried to craft a bill that could foresee the unexpected.
Sorry, Mrs McCarthy.
Thank you, President. Attorney, since we've now heard from Mr Somyurek, when we were here last, you said that bill that was so urgent we had to pass it with great speed at the time we were in the chamber, but then it had to be, you had to defer it so you could brief Mr Somyurek. How did that briefing go, given his statement?
Attorney?
Mr Somyurek didn't accept my invitation for a discussion about this bill.
Mrs McArthur.
Thank you, Deputy President. Well, Attorney, then the reason why we abandoned ship last time was irrelevant in that case. There was no need to brief Mr Somyurek, but in actual fact it was to persuade a crossbencher to change their mind. Is that the case, Attorney?
So, Mrs McArthur, you need to confine your questions to the substance of the bill. If the attorney feels she can make some statements about her briefing to Mr Somyurek, that's fine, but we do need to make the questions relevant to the actual bill, to a clause in the bill.
Well, thank you, President. It seems to me the discussion has been extremely wide-ranging up to now, and statements have been made by a number of people, but we are in this point because you insisted that we stop the debate so that we could brief Mr Somyurek. That appears not to have happened.
Attorney?
For him whether he accepts a briefing or not, but it was not the only reason that the bill was paused. And I am very upfront about the fact that I don't think I will ever proceed with a bill that is probably, that I don't have the numbers on, because it would be a disingenuous symbol to the Victorian public that we're going through a pantomime of a bill that is going to be defeated. And it would have been, as I've been on the record in this chamber many times, there is a lot of important legislation, not just this bill, that we need to proceed to. So to take up a day of this conversations about a bill that the opposition indicated that even if their amendments were successful would defeat, would have been a waste of everybody's time.
Mrs McCarthy.
Thank you, Deputy President. Thank you, Attorney. Can I ask then, in clause 1A, it states that a purpose of this bill is to enable, quote, the effective management of pandemics. So, Attorney, does the government therefore believe that it did not effectively manage the pandemic, which is why this legislation is apparently required?
Attorney.
Thank you, Deputy President. No.
Mrs McArthur.
Deputy President, well, Attorney, if the government doesn't concede that it did not effectively manage the pandemic, why is this legislation necessary?
Attorney.
Well, Mrs McArthur, your side has made it quite clear that they don't believe that there should be a framework to protect the health and safety of Victorians. This government fundamentally disagrees with you on that point.
Mr Limbrick.
Can I use this one? Yeah, thank you. Thank you, Deputy President. I'd just like to clarify a couple of roles, a couple of issues on the record for the role of the Ombudsman. So we were talking before about the role of the Ombudsman. They can review the implementation but not the decision-making process. So I note that in the housing towers, in the investigation into the housing towers report, the Ombudsman came to some conclusions around whether a decision breached human rights, whether because it was done in a short time frame. Would that type of review not be possible on the decision, but only on how people acted after the decision was made now?
Attorney? Attorney.
Mr Limbrick, the decision that the Minister makes is not reviewable by the Ombudsman, but the flow and effect of the decision is. So the implementation, the execution of what flows from that decision, the operation, the impact on people is what her job is to do. The decision-making, the decision that the Minister makes is subject to parliamentary scrutiny, which is why we've established originally SARC, but now a arguably greater independent joint parliamentary committee focused on these particular issues.
Mr Limbrick.
Thank you, Deputy President. I thank the Attorney for her answer. On that report that the Ombudsman wrote,
I think you did ask me. She can still do that after this framework. Yeah, sorry.
Thank you for the clarification, Attorney. One of the recommendations that the Ombudsman made was around the detention powers, and she recommended that anyone detained under these powers should be guaranteed access to fresh air and exercise, and that an amendment to the Public Health and Wellbeing Act should be made to reflect that in the detention powers. The Liberal Democrats have previously put forward an amendment to this House previously. I think it was on the last State of Emergency extension, and that was defeated by the House. And I note that this new legislation doesn't include those sort of protection for those rights either. What was the government's reasoning for not including a guarantee of fresh air and exercise for detainees?
Attorney.
Mr Limbrick, I was just looking for my summing up comments, because I did address these issues that the detention guidelines would deal with the provision of fresh air and the like, as you have articulated. So there is a commitment to ensure that those are picked up in the guidelines.
Ms Limbrick.
I thank you, Deputy President. Thank the Attorney for her answer. So these sort of issues about how things will, like what sort of rights will be prioritised, for example, will be handled through guidelines rather than legislation. Is that what you were saying, Attorney? Yeah. Okay. Thank you. So on another right, which I've raised many times, and it was also raised in the second reading debate, was around the right to peaceful assembly. We've seen I would characterise as disastrous attempts to suppress that right almost totally. What sort of commitment can the government give to ensuring that, at least some sort of harm minimisation approach to facilitating that right would exist in the future?
Attorney.
Mr Limbrick, I did refer to this in my summing up because it was a particular of particular interest to the Greens, and so I had outlined this in my summing up and would want to refer you to those comments. But indeed, they are will be covered in the compliance and enforcement policy that will be developed.
Thank you, Deputy President. Minister, Mr Lean passed me a list of the stakeholder consultations, thank you, when I was speaking previously, and I note that there was, on this list, legal stakeholders, human rights, public health, community groups, social service, public housing and information protection, meaning the OVIC and Health Complaints Commissioner, that were consulted prior to the tabling of the first bill, but there was no business. And it was only after the bill